Hello dear friends, namaste to you all. I am now going to discuss on layoff and retrenchment. I'm going to discuss on layoff and retrenchment. What is layoff? What is retrenchment? We have already defined when we took up the definition part or interpretation part of this Industrial Disputes Act, and we will look to the details of layoff and retrenchment in sections 25 C, D, E, that is layoff, and section 25 F, FF in the case of even H deals with in the case of retrenchment. But for that, in order to be entitled to compensation, then 25B are also essential. What is section 25B and what is the relevance of that section 25B? All that you will come to know. We will discuss what is layoff, under what circumstances a person could be laid off from the work, and what is the consequence in case if the employer lays off the services of the workmen, whether it will separate, whether there will be a severance of the relationship between employer and employee. It is not so. In the case of layoff, employer-employee relationship will be intact, and only thing is that the work could not be given by the employer on account of some compelling reasons, inevitable reasons. If the work is still given, if the employee is still continued in the employment, then probably he will have to be paid, full wages. If full wages paid, when employer is unable to, bear the same on account of some inevitable reasons for which law allows, employer can lay off, employer can keep away the service of the workmen on account of those, so as to cope up with, so as to balance, so as to save the establishment from suffering further. And those problems cannot be, adjustable as such in such cases. What are those? It is one, it's a temporary inability on the part of the employer to give work to any number of the workmen whose name is borne in the muster roll of the industrial establishment, and it must be due to on account of any of the following reasons. One, shortage of coal, raw material and power. Shortage. Second one, breakdown of machinery. Third one, lack of marketing, or it can also be called accumulation of stock. Lack of marketing or accumulation of stock. And then fourth one, natural calamity. And then fifth one, any other reasons other than those specified in the above. For these reasons, in order to mitigate the loss margin, in order to in order to prevent further losses, what employer can do, work cannot be given with on account of any of these reasons. In which case, employer can, keep you aside, lay your services off, either for the half day or for the full day. As we know, for your entitlement to layoff compensation, you must have put in 1 year of completed service for every year. You must have put in 1 year of completed service. For every year of completed service, you should have completed 1 year of continuous service. What is that? 1 year of continuous service. 1 year of continuous service is defined in section 25B. How it is defined? Section 25B defines 1 year of continuous service in the following words. 1. A person is said to be completing 1 year of continuous service, if he has worked, if he is working on the ground, above the ground, if he has worked for 240 days and above, or above, in a calendar year, that is starting from January to December, that workman should have completed at least put in 240 days of work or above, 240 days of work or more in the preceding 12 calendar months. 12 calendar months he should have put in if he is working on the ground. If he is working below the ground, below the ground, that means we can call it as hazardous employment, then at least in the preceding 12 calendar months, he should have worked for a period of 190 days of work. Okay. So over and above that full year of continuity service, if at all any fraction remains, then fraction of 6 months and above will be considered. A fraction below 6, over and above 1 year. Over and above 1 year, if there is any fraction, then it should be 6 months and above, so as to consider. If there is no 6 months, then it will be treated as that year only, and that fraction of less than 6 months will not be counted. But if it is 6 months and more, it will be counted. What for? I will tell you. A person could be laid off from the service, from the work, from the service. No. It is a person. Who can be that a person? Any person whose name is born in the muster roll of the industrial establishment, due to the temporary inability of the employer may resort to lay off the service of the workmen on account of these reasons. And for that, the procedure is that employee shall report to the place of establishment at the appointed hour, and if he is told that he will not be given work on account of any of the reasons for the first half, then he will be laid off for the half day. For the whole day, if he is informed that you will not be given the work for the whole day, you are laid off for the whole day. Similarly, for tomorrow or any other day, your duty as an employee, you must report to the place of establishment at the appointed hour, and you may be waiting there. Suppose if the appointed hour of work is 9 o'clock, you must be there at 9 o'clock. Suppose if at 9 o'clock you are not told, you can keep continuing, you can keep waiting for not beyond 2 hours. Wait only for 2 hours, not beyond 2 hours. And within the 2 hours, if you are not told anything, it is deemed that you are laid off for the day. So you can be laid off for half day, you can be laid off for the whole day. What about next day? Next day, similar process you have to follow, that you need to come to the employment premises at the appointed hour, like that. Okay, right. You must be a workman, your name must be more in the muster roll of the industrial establishment, and you are not given work, you are told either you could be laid off for the half day or whole day. You have presented yourself at the appointed hour at the place of establishment every day, and then if you are not given the work and told so on account of any of these reasons, you are laid off and you are entitled to compensation. What is the compensation? 50% of the wages applicable to the day. Okay, right. Suppose if you are laid off for a half day, then you will be you will be entitled to layoff compensation even for the half day. What is that? The full wages for the half day. Out of that, 50% of the wages will be payable to you. Like that, in a calendar year, you can be laid off only for 45 days with the compensation. 46th day, normally there is no provision in the law, but since if the loss making situation or any of these reasons did not improve, then employer will go consider it as continuous losses, and employer will then go for what is that called? Retrenchment. That is, severance of the relationship will happen. Under what circumstances a workman who will be entitled to layoff compensation? Who will be entitled to retrenchment compensation? Any person who has completed 1 year of continuity of service. Under section 25B it is defined. Who is that person who completed 1 year of continuity service? A person is said to be completing 1 year of continuity service if he has put in 240 days of work or above, if he is working on the ground, or if a person is if the workman is working below the ground, in which case, in their cases, if they have put in 190 days of work during the preceding 12 months, that is enough. He will be entitled to compensation. So they should have put in 1 year of continuity service. That is also there. Under what circumstances the workman laid off will not be entitled to compensation? 1. When he is not presenting himself at the place of establishment at the appointed hour. 2. If he is given alternative employment which doesn't call for any other special skill than the skill required here in the work where he is laid off. He is given alternative employment, but he has refused to accept the alternative employment, then workman laid off is not entitled to compensation, provided that alternative employment is given in the other establishment or in the same establishment of the employer or in other establishment of the employer situated within the radius of 5 miles. If it is beyond the 5 miles workman, you are entitled to compensation, layoff compensation. But here you are laid off, but your employer is having one more establishment. He requested you, he asked you, work there with the same skill or lesser skill, work there. An alternative employment. Where is there? There means from here to there it is hardly about 6 kilometers. That's okay still, because law says if the alternative job is given in other establishment of the same employer, which doesn't call for any other extra particulars, special skills, then if the same is situated within the radius of 5 miles, then employee shall accept, workman shall accept the work, alternative work. If he doesn't accept, he is not entitled to layoff, compensation as such. Okay. And then if the layoff is due to the strike or lockout, if the layoff is due to the strike, no lockout, if the strike is due to if the layoff is due to strike in other part of the establishment, since the work here is linked with the work of that other part of the establishment where the strike is going on. When the strike is going on there, no work could be given here, you are laid off and you will not be entitled to compensation as such, right? Then we will proceed to retrenchment. What is that retrenchment? Section 25 says retrenchment. You know the meaning of retrenchment. You know the meaning of features of retrenchment. 1 month's retrenchment means if the inability of the employer, if it is a continuing one, if the inability of the employer, if it is continuing one, then employer may terminate the service of any number of the workmen whose name is borne in the muster roll of the industrial establishment by giving adequate notice. But the following are not retrenchment as I referred to in the definition part. One, retirement. Another one, voluntary retirement. Another one, retirement on completing the contract of employment. Or other words, it is not retirement. Termination of your service on account of completion of the contract period of employment. For termination on account of termination from the service on account of your completing the age of retirement, termination from the job on account of your voluntary retirement, termination on account of your expiry of the or completion of the contract of employment, termination on account of indiscipline or dismissal, and termination on account of continued illness. Termination on account of continued illness. These are not to be termed as or these are not to be terming as retrenchment. They are terminations on account of specified reasons. They are not retrenchment. So therefore, barring these, every other kind of termination is known as retrenchment. But you must be beware of that. Usually retrenchment happens in order to terminate the service of surplus labor. When surplus labor will happen? Usually the surplus labor will happen when there is no marketability to the product that you are, service you are producing. When there is a breakdown of when there is loss like situations continuing. In such cases, if it is a continued loss, then employer will go for termination from the service, and there is a procedure for such retrenchment, namely procedure. Okay, you know the retrenchment, you know these are not retrenchment, then therefore procedure. What is that procedure? To terminate the service of the workmen on account of surplus labor, on account of continued losses, employer shall observe certain procedure. Namely, 1 month notice in writing indicating the reasons thereof for termination of service by way of retrenchment. Or if you are not going to wait for that 1 month, then in lieu of 1 month you can pay 1 month wages, and straight away from this day itself you can terminate the services on account of retrenchment, on account of continued losses. Mr. Employer, it is possible. Either give him 1 month notice and wait for the expiry of 1 month notice, or give 1 month's wages and terminate him from the service by paying the compensation. That is important. 1 month notice in writing or 1 month wages in lieu of that notice. To compensation equivalent to 15 days of wages, average pay. Compensation equivalent to 15 days of wages for every year of completed service. How many years of service you have completed? If you are now 15 years service completed, all these 15 years, did you complete 1 year of continued service? Yes. Then you will be entitled to 225 days of compensation, average pay. What is that average pay? Based on, what is the average pay? If you are a monthly paid workman, immediately preceding 3 months, it's average. If you are weekly paid, means 4 weeks immediately preceding and average. If you are a daily paid workman, means you are to be paid, you are to be paid the compensation on the basis of the average of the wages that have been paid to you during the preceding 12 full working days. That's how it is. So, retrenchment compensation equivalent to 15 days of wages payable to you for every year of completed service. Got it? 15 days of wages payable to you for every year of completed service. And the third one, notice in that effect should be served on the appropriate government. Understand? Notice also shall be served on the appropriate government. That is the third condition. Okay? 1 month notice in writing or 1 month's wages in lieu of the notice. Then compensation, retrenchment compensation equivalent to 15 days of wages, average wages, 15 days of average pay, 15 days of wages, the compensation equivalent to 15 days of average wages payable to him for every year of completed service. And if you are a 15-year-old in the service, then you will be entitled to 225 days. Like that, for every year of continuity service, you are entitled to 15 days of wages as compensation. Okay, average of the wages. What is the wages immediately preceding? If you are retrenched this month, that is the month of June, May, April, March, how much you have drawn? Draw the average pay, and when you get the monthly average pay, draw the daily pay, divide by 30, that monthly average, you will get daily wage, daily average. A daily average into 225 days, that is the retrenchment compensation. And 3, notice in that behalf to be served upon the appropriate government. And 4, that retrenchment must be on the principle last come, first go. Last come. Whoever last appointed will be the first one to be sent out by way of termination, by way of retrenchment. So last come, the principle, the termination of service by way of retrenchment must be on the principle last come, first go. On this basis only, the services could be terminated. Right? Then we will have to proceed. In case of transfer of undertaking from one owner to another, when the establishment is transferred from one owner to another owner, then whether it amounts to, see, I am the present owner. I have appointed 200 employees, and when I transfer the undertaking to Mr. B, whether my employees will become the employees of B owner, 1, 2, whether their service conditions, terms of employment, etc. will find a change. Yes, if at all it finds a change, if the service condition is going to be a new one, then in which case Mr. Employer, A employer, that's the first employer, he transferred, he should pay compensation, retrenchment compensation, any other compensation. But if the service conditions of, the employees in A establishment, upon transfer it will become B's establishment. If the service of the employees of A establishment are not going to be altered and they will continue to be the same under the B employer, then no need of retrenchment compensation as such, right? And all that obligation regarding all facilities and liabilities, etc., will become that of Mr. B under the agreement between A and B. Therefore, there is no retrenchment as such. The transfer of undertaking will constitute retrenchment, will not constitute retrenchment. Both you have to substantiate. It will constitute retrenchment when there is a change in the service conditions. When entirely new service conditions are introduced under the transferee establishment, then transferor establishment is bound to comply with all the provisions for compensation, like closure compensation, like retrenchment compensation, etc. Retrenchment compensation, not closure compensation as such. Any other leave, etc. Those are all to be paid. Yes. So in case of transfer of undertaking, whether the service conditions are likely to be altered, in case of service conditions alter, suppose if it is altered from transferor company to transferee company, then the transferor company, while transferring to the transferee company, transferor company shall be liable for those compensation like encashment of earned leave, like retrenchment compensation, like gratuity, like whatever that is applicable. It is as good as termination. Okay, but if it is not going to be altered, service conditions will remain the same as was in the case of a transferor company, then this transfer of undertaking will not entitle the workers of a transfer company to any compensation as such, because same thing will be continued with the transferee company as such. So these provisions you will find in the case of layoff and retrenchment. Okay, right. And then finally, in case if the employer violates or contravenes the provisions of layoff or retrenchment, etc., then he will be liable for penalty as such, and that penalty may range to 5,000 rupees as such. If it is a repeated one, it may attract even prosecution if he doesn't follow the same, right? Then there is one provision, recovery of money due from the employer under section 36. Now let us proceed to, this is what let us proceed now to Standing Order Act, Industrial Employment Standing Order Act 1946. Industrial Employment Standing Order Act 1946. Usually what happens, regarding relating the service, the industrial relation, that's the relation between, usually the relation between employer and employee, employer and workmen, there is always one form or the other form of rift, industrial rift, connected with any matters of employment or any matters of employment. There is one form or the other form of a rift existing between employer and employee, employer and workmen, and usually the cause of the rift is that they are not, the employee or the workman, not happy with the way it is being functioned, the establishment is functioned, or not happy with the way the employer is conducting, or not happy with the way in which employer sets the rules of discipline, or rules of what is that called, rules of day-to-day affairs. Usually there will be rift. When there is rift, then that will affect the quality industrial relations. As you know, when there is some sort of a difference, when there is some sort of a rift, when there is some sort of a dispute like or unhappy like a situation, then there will be no industrial harmony. When there is no industrial harmony, a workable relation does not exist. A workable and healthy relationship between employer and employee is a must for any peace, for any prosperity. If industrial peace or industrial prosperity is to happen, then that workable relation must exist between the concerned parties. And in order to ensure the same, because one thing is pretty sure, that when there is no defined rules, when there is no law, then that creates confusion, and that confusion may take us to some extent that we don't follow anything. But when there is some law, then sort of orderliness can happen. Some sort of orderliness can happen. Employer will say, hey, employees, don't do that because there is law which says this. Employee will say, employer, don't do that because the law says like this. And both employer, employee, like as we do, both employer and employee, they will keep themselves quiet. They will show some sort of habitual obedience. They will habitually follow the law as such. Be it, even if it is made by legislature or the parliament or bureaucracy, they will still be obliging because it is made by the approved authorities. When it is made by the approved authorities, when it is violated, they will attract a penalty. As such, you will show that habitual compliance to those. You understand? But whatever told by the words of mouth, employer tells the employees to be like this, like that, employees will not. Whatever told by the employer in writing, employees will not, workmen will not, because they will not express their happiness about the way, hey employer, you have designed that rule, you have designed that notice on your own, how can you do it? And look at this. some sort of awkward situation, some sort of a different like a situation will exist. And therefore you must make aware of the workman, you must make aware of the employer also. Employer too will have to maintain the discipline. You must make aware, you must give knowledge. As you know, Consumer Protection Act or Right to Information Act, see, whatever Environmental Act, whatever is there, but there is a need to show some sort of obedience. That is an obligation. And when we show our respect, when we can show our respect, when we can show our compliance to environment, to consumer protection of consumer rights, when we know the law. So it is the obligation of the lawmakers. After having passed the law, there should be provision, there should be sufficient arrangement to be made for spreading the awareness about the objective of the said law. You simply passing a law, legislature or the parliament, that is not enough. You should make aware of the concerned stakeholders. You should make aware, like a consumer protection means you should make aware. You should spread the knowledge, you should spread the training. Why? So as to make them aware of their respective rights and obligations. And when you make them aware, then what happens, when you make them aware, what happens is that what is intended, that will happen. What is intended, that will happen. Remember. And what is intended by Consumer Protection Act? Grievance of consumer, what is that? Grievance of consumer grievance, redress. What is that? Settlement of consumer grievances. 1. Remedies. 2. And even the consumers will be made aware of their rights, etc. Likewise, workers, employees, what are your obligations? What are your rights? And what is the relevance and utility of maintaining maintaining a peace or quality or healthy relations? And what will be the consequence of if healthy relation not maintained? What will be the consequence otherwise? What is the quality? What is the utility of peaceful and quality relation or healthy relation, workable relation? And what will be the consequence otherwise if the workable relation does not exist? These many things, these many issues will happen. In order to avoid the same, we go for a law-like situation. As I said just earlier, we follow. I don't commit a crime because there is IPC. You don't commit a crime because there is IPC. Of course, a small percentage may commit violations, but substantial 99.9% of population will oblige the law. Likewise, the employer, employee, let their relationship not be defined by by the relations. Let their relationship not be governed by words of mouth. Words of mouth as and when it is spoken. No. If that is so, then rift or dispute like or differences will crop up and go beyond the proportion of any settlement or redressal. Therefore, there is a need. And the very same parliament passed quality workable industrial relation is a must to ensure discipline. And when there is a discipline, then there is a growth or development possible. And discipline will come. Discipline will not come that easily. Discipline will come when it is shown through a law. And when there is a law passed by the parliament, inevitably, habitually, we will comply with that, obey with that, and that results in a healthy relationship. And out of healthy relationship, when we enjoy the peace, we can do the impossible ones. When we do not have the peace, even the possible ones becomes impossible. That is said. Therefore, discipline is a must for both employer and employee. And that industry, so as to promote the industrial discipline, connecting anything, the Parliament has passed in the year 1946 Industrial Employment Standing Orders Act. What do you mean by standing order? Standing order is a rule set out by the employer. It's a set of rules framed by the employer with reference to the matters contained in the schedule. And what all those matters, I'll just quote, that is what for I have referred to the book. What all those matters in respect of which employer, before that let me also tell you why those set of rules to be made, why those powers are conferred upon the employer. What is the relevance of the conferment of that power to the employer? What will happen? If you leave it to the employees, then it will be one-sided. If you leave it to the employer, that will be best-sided. Reason is that it's the employer who invested the capital. It's the employer who knows, because employer is one, you are many. When the provision is given, provision of framing the standing order is given to the employee, then there will be utter confusion. Therefore, employer will frame, but employer, you also beware how to frame it. We will come to that. But employee, when it is framed by the employer, in respect of what matters it could be framed, it is set out in the very, central statute, central, enactment, that is Industrial Employment Standing Orders Act 1946. This Standing Order Act 1946 is a guideline. It's an enactment which guides the employer, which empowers the employer, which empowers. So employer in a way, and according to this act, is a rule maker. Remember, employer is in a way, according to this act, is a rule maker. He can frame the rules of discipline concerning the matters connected in the schedule to the Industrial Employment Standing Order Act. And it will not be instantly, whatever rule he frames, it will be called a draft. And for its approval, certification, he has to submit to the certifying authority as such under section 5. And from 3 to 5, the provision is there for certification. What I intend to tell you that the employer can frame the standing orders in respect to the matters contained in the schedule attached to the Industrial Employment Standing Order Act 19. What all those matters contained in Industrial Employment Standing Orders Act 1946 schedule? They are: 1. Classification of workmen, whether permanent, temporary, apprentice, probationer or badali. So therefore, a set of rules could be framed in respect of the matters contained in the schedule, and these power have been given to the employer. Okay, he can frame the draft rules and submit in 5 copies to the certifying officer to get it certified. The certifying officer will follow the procedure which I will tell you now. When the employer frames the rules in respect of what? In respect of these matters, like a classification of workmen, whether permanent, temporary, probationary or apprentice, badali. Then next, the manner of intimating the workmen regarding the period and hours of work, regarding holidays, regarding payday, regarding wage rate. You understand? The manner of intimating to workmen in relation to hours of work, periods of work, the holidays, the paydays and the wage rates. That has to be framed. Then shift working. How many shifts are there? Whether you can be changed to from one shift to another shift procedure. The attendance and late coming. Regarding the attendance and late coming, Mr. Employer, you can frame the rules. Okay, in order to ensure, you can frame even a rule like in order to ensure the prompt coming. What is that? We used to say, he is very punctual. In order to ensure that he is a timely arrival in the place of establishment, and without delay, without taking leave, if he is very regular, you can promote incentives, contain them in the standing order, which will enable the workers to be aware of, and it will ensure that they will be very regular, punctual, etc. Then the requirement to enter the premises at certain gates and liability to search, closing and reopening the sections of the industrial establishment, and temporary stoppage of work, rights and liability to the employer and the employee during these times, the termination from the employment and notice thereof to be displayed, regarding the reasons. Notice shall be given to the employer and employee regarding the same. What are all the grounds when the service of the workman, service of the employee will be terminated? Such must be given. These are the grounds on which you could be terminated, so that you will not commit the same. Then the means of redressal of workmen, means of redressal of grievance of the workmen against unfair treatment or wrongful exactions of work by the employer or his agent or servants, and any suspension, dismissal for misconduct, what amounts to misconduct, etc. In relation to these, I said starting from the service conditions, ending with the disciplinary actions, or any other particular, from time to time it may be prescribed by the government. employer is vested with the authority to frame in respect of these matters contained in the schedule to Industrial Employment Standing Orders Act 1946. Okay, whatever rules. So what do you mean by standing order? Therefore, set of rules framed by the employer in respect of the matters contained in the schedule attached to the Industrial Employment Standing Order Act is known as 1946. What is the utility of discipline in the industry? Write pages together. Because without the industrial discipline, without quality industrial, without industrial peace, without industrial harmony, nothing is achievable. As I said, even the possible ones becomes impossible. Therefore, quality industrial relation is a must. It is a condition precedent for the industrial prosperity as such. What is the procedure? Employer, in respect of those matters as contained in the schedule, frame the draft standing orders as applicable. See that you are giving Mr. Employer, while framing the draft standing orders, you are giving what is that? You are giving representation to each and every matter set out in the schedule. You are giving coverage to each and every matter set out in the schedule. They must be given what is that? They must be given priority to each and every matter. And when the employer frames a draft rules in respect of these matters contained in the schedule, if the coverage is there, it's wider, it's as good as complete, then write, after framing the draft standing orders, I don't know whether you will draft on your own or whether you will while drafting the same, you will hear the other side. Other side is workmen or their trade union. It is up to you. And now, after framing the drafting orders where coverage is given to all the matters almost contained in the schedule, then you submit them in 5 copies along with the along with some statement regarding what is the nature of manufacturing process, how many persons working in your establishments. Regarding the same, a statement shall be served by the by the employer as such. Okay, and it should be the draft standing orders when it is submitted to the certifying authority, since it is accompanied by a statement giving prescribed particulars of the workmen employed in the establishment, including the name and including the name of the trade union to which your employees belong. These particulars shall be submitted to whom? These particulars, when you submit the draft rules in 5 copies to the certifying authority along with the statement that how many number of employees working in your establishment plus is there any trade union to which they belong, this statement you have to be giving, and ensure that while framing whatever you have submitting the draft standing orders, ensure that such a draft standing order is framed in respect of each and every matter set out in the schedule. And when it is given to the certifying authority, who is the certifying authority? That may be the question. A certifying authority is a person appointed in this behalf by the appropriate government. You understand, with the requisite qualification. A certifying authority is a person with the requisite qualification to be prescribed from time to time by the appropriate government, and it is the appropriate government, the state government, appoints a certifying authority to whom you need to submit the draft standing order in 5 copies. Okay, and the employer, you should also be taking the care, plus the certifying officer, you should ensure when the copies you are receiving that employer has given coverage to each and every matter set out in the schedule. Then you will also have to the employer, the certifying authority, also to ensure that whether a statement is accompanying the draft standing order submitted by the employer showing the total number of the employees working in the establishment plus the name of the trade union to which these workmen belong. If these particulars are submitted, then upon receipt of the same, the certifying authority will furnish a copy to trade union or workmen. they will submit a copy to trade union of the workmen for their consideration. And the trade union or the workmen, within 15 days from the date of the receipt of that copy or notice along with the copy of the, upon receipt of the draft standing orders in 5 copies, the certifying authority shall send a copy along with shall send a notice along with the copy of along with 1 copy of the draft standing orders to trade union or its workmen. And this workman of the trade union shall within 15 days from the date of this date of the receipt of this notice, shall within next 15 days reply to whom? Reply to certifying officer. And this certifying officer, upon receipt of, yes, now the trade union will submit its reply within 15 days. Suppose if the 15 days time is not enough, then you may request, but as such the certifying authority for extension of thereof. But as such, the certifying authority shall be replied with by the trade union if there is any objection. Okay, you have replied, your trade union has replied, and upon seeing this reply, if the replies are genuine one, then it will certifying authority will proceed. See, actually, this is one drawback that exists in the present act. When the reply is given, draft standing orders are in 5 copies have been submitted by the employer to the certifying authority. On receipt of the same, certifying authority will as soon as possible send a copy to trade union. Trade union from the date of its workmen, they from the date of the receipt of the notice within 15 days shall furnish their objection to certifying authority. Furnished. But there is one drawback, is that after receiving the objections, it should give a notice to the employer too. See, these are objections, these many objections have come, and therefore what is your reply? But what he does, if the objections are well founded, he will incorporate them and accordingly modifies the standing orders and then finally certifies the same. And once it is certified, as soon as possible, you may send the copies to the employer, who within 7 days from the date of certification, it has to be displayed by the employer as such.